going on? How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Chunky! I didn't say.
Eat your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
What's going on? This is Colin. How's everybody doing? I hope you're having a great day so far. I've got a good one. We are in front of Judge Garcia out of Texas, and we have what might be the origin story of a sovereign citizen. I think he's going to go full soft-cit in his next hearing. Right now, he's just a soft-cit adjacent, or a soft-cit, as I like to call them. But he comes to court. This is a civil matter. It's a debt collection with a bunch of motions. And he makes a few of the soft-cit arguments for debt deniers. You'll hear them, and I'll point them out when they happen. But let's get into it. Before I hit that play button, you know what to do. Hit the like and subscribe. Do your jump kick backflips. Let's go.
Okay, with Mr. Spencer. Okay, and Brandon, what was your case?
Yes, Your Honor. It is Capital One Bank versus Joshua R. Jones.
Okay, I don't. This one looks like it's going to be a little bit more complicated. He's got a lot of motions. I don't want to be interrupted. So give me 1 minute. Y'all might be the last ones just so you can have my full attention, because I do know that you have filed and you do have some evidence. So I don't want to have to stop and then have to reevaluate where I'm at. So I want to give you my full attention. So give me 1 minute, Mr. Brandon, okay?
Okay, just real quick, Your Honor. I don't believe this is a trial setting. On the notice that we got, it's a notice or a hearing on the defendant's motion, on his motions that he's filed. He had mentioned wanting to possibly get an attorney. So I don't know if we just want to continue it today and set it for trial, and then, or how you would like to proceed, but
Okay,
we don't have.
come on up real quick, Joshua. Real quick. Let me make sure. Let me get to this case and see.
Am I able to hand you something, Your Honor?
Yes, go ahead.
To make it super simple for you, I kind of sectioned off certain sections for you. That way, instead of reading through maybe a court docket.
Okay, but real quick, Mr. Joshua, before,
ma'am.
because we're not going into trial right
Gotcha,
now.
yes, ma'am.
My question to you is,
Do you see the
right
nature of
here,
it?
it's a hearing on the defendant's motions for today, so it's not gonna be set for trial today. My question is, are we gonna go through each motion so that I can either dismiss or approve it? Or are you gonna hire an attorney?
So realistically, at this time on hiring an attorney, I'm still iffy. I'm 50-50 on it. I've prepared a lot and I've done a lot of personal
I
research.
see that,
And then I didn't attach it necessarily to this, but on my other case, I actually have all the case law that in the state of Texas that has presented, that has ruled in the, for the defendant on. the
based on your
ground.
situation. Okay.
Correct, yes, ma'am.
So real quick, my question is, again, are we gonna go through the motions, or do you want me to give you time to hire an attorney to see if they can file something else? Or, because if not, I'm gonna have to go through each motion, and that's all we're doing today. We're not gonna have
I
trial.
would go through each motion today.
Okay.
I would still have an opportunity later on in the future if I decide to bring in an attorney. Would I still have that opportunity?
Well, yes and no, but if you bring an attorney later on at that point,
Mhm.
him requesting a reset, council is probably gonna object to it, because we're giving you the opportunity now rather than later. Because if you try to bring it in later, all the attorney's gonna do is gonna ask for an extension, because he needs to get caught up on this case before we have a trial. So that's why Mr. Brandon is saying, if you're gonna hire an attorney, you need to do it now before we set our trial date, because we're not gonna push that back. And your attorney, if you hire it later, is gonna need more time to prepare rather
I'll
than.
tell you, then I believe that I have enough actual information, and then with my timelines and certain things that I have on my file, plus all those documents over there, I think I'm
Okay,
defend myself.
okay, so for today, we're just going for the motions, so,
Yes, ma'am.
okay, so we're gonna go through each motion then, Mr. Brandon, give me 1 minute.
Okay.
And let me see,
So
you,
I apologize. Yes, ma'am.
go ahead, if we're just going through motions, Brandon, are you ready?
Yes, Your Honor.
Okay, but again, my apologies ahead of time if I have to stop you while I put Mr. Orlando in breakout room, so these other people don't just sit here. Give me, I'm gonna have to stop the trial
1000%
for a
respect.
minute, or not the trial, the hearing. All right, Okay, give me 1 minute. Mr. Spencer is back. Hold on. All right, all right. Go ahead, Mr. Joshua, talk to me. What's going on with your first motion you want me to hear?
So when you say the first motion, I filed motions way back in February. So, but I also have the one that I just filed. So I'm gonna go ahead and start with that one.
And that one is your motion to dismiss for lack of service, failure to prosecute, and procedural non-compliance. Is that correct?
That is correct. Yes, ma'am.
Okay, go ahead.
And so, originally what ended up happening is on December 4th, the plaintiff actually filed a suit against me. At that time, I had no idea what was happening. Through going through the court docket on a different case, I ended up discovering this. Now, if I'm not mistaken, TRCP, or I might have the acronym wrong, 106 states that just because I discovered something does not mean that, service is void. Service is still, required in the state of Texas. What else? I apologize. And then on that matter, I have also been keeping an extremely,
All right, just real quick. He mentioned TRCP. That's the Texas Rules of Criminal Procedure. Just wanted to make sure I said that so you guys didn't fall behind.
been kind of, almost nudging at them in a professional way. And what I say about that, on December 4th, they filed.
Mhm.
On, March 3rd, when I finally found out that they filed, I submitted answers. On March 7th, I submitted answers plus amendments. On March 7th, again, I put in an initial motion of discovery. On the 21st, I filed a supplemented motion of discovery requesting additional records. On the 21st, again, I also filed a motion for judicial review seeking court oversight. The reason why I asked for judicial review is because I sent there so many documentations, so much under certified mail, and there was no response.
To them.
To them, there was no response, which means that doesn't show me any kind of professionalism on their side. If they wanted to solve, they just kind of saw it as a wham bam, thank you, ma'am, this case is dismissed. At least that comes across to me in that way. So yeah, he kind of argued the point that, oh, well, he filed the answer, but underneath the TRCP rule, it's just not a defendable, it goes against that rule that's written into the law books. Now, he told me that if he files an answer, if he files a suit, like he gives me a discovery, it's going to be pretty much the stuff that he already has originally on the court docket. So realistically, I do have those documents, but I've asked for discovery. And the reason why I've asked for discovery, in this document that you do not have a copy of because they submitted to me, it starts with the address of 23315 Skiller Drive in Elmendorf, Texas. It's not my address. It does end up at my address in 2022, but pretty much up to that date.
So you have no knowledge of that address?
I had no, this is the file dump that they gave me right before.
But
court.
that address on there, that
Yeah,
you don't,
I
you
don't-
don't know where it came
I
from?
don't. Also, I asked them for verified documentation, like, hey, you know what? That was a long time ago. I'll tell you what, go ahead and send me a wet signature. Go ahead and send me the confirmation of agreement. They're the direct people. They should be able to get that pretty quickly, I would assume. And they didn't put that in they didn't give me any of those. So pretty much they kind of left me in limbo for a very, very long time. And it really caused me to almost do a Hail Mary swing at defense because I knew I was going to get to court. And to be honest with you, with my ex-wife, she got a default judgment against her in the same way because she never got a paper. So I explained that to him that no, I showed up because I don't want a default judgment against me. But no, I have to defend this.
Okay, give me 1 minute. Go ahead, Mr. Brandon.
Yes, you're
All right, here's my biggest thing. First off, he did say wet signature. But that's nonsense. But he never said that wasn't mine. Never said that one time. He's arguing procedure to get this case dismissed. So even if he got his wish and got the case dismissed, they would just refile it in whatever form that was, apparently a mistake. But listen to what the attorney says. They're covering all their bases. This guy he's trying really hard. And this is why I say he's a sovereign citizen adjacent. And I do believe he's going to go full soft-cit during trial. Just his arguments they're out there. They're not going to work. He does drop subject matter jurisdiction here shortly, but the judge cuts him off halfway through a sentence, and it's hilarious. But the attorney, he's a little bit green. I'll say that. But I think, you know what? Let's just play it.
Your Honor. So what he's showing you is in his answer, he had disputed the debt. And so we had to send him a validation of the debt. And that contains a letter and statements from the account. That is not something we are using as evidence in the court, which is why it never got filed, but we're required to send debt validation when they dispute it. We are in the process of preparing our offering of evidence, and the court had not granted any order of discovery. So him sending us all these motions for discovery, we're not obligated to respond to that, especially when he's asking for things that aren't typically provided in cases such as this. And as far as the service goes, we're more than happy to show up at his doorstep and hand him a copy of documents he already has. But when a defendant files an answer, service is almost moot at that point because they have everything they're going to receive from service of the petition. The offering of evidence will be sent to the court and have a certificate of service that we will also mail to him.
Will the person who's offering that offering of evidence be willing to testify?
It is a business
I'm
record
just asking for
affidavit.
everything that's submitted to be validated through an actual person's voice.
Hold on. Go ahead, Mr. Stan.
That is not typical procedure.
That's
It's
what my defensive ground is, though.
Okay, I understand what you want, but it's not necessarily what is required. Okay,
Yeah.
so give me 1 minute. Well, I do hear you though. Go ahead, Mr. Stan.
I'm not aware of any time that has happened. So I can't even say if they'd be willing to or not. The legal standard is we need a business records affidavit, and that will be provided in the offering of evidence.
All right, so my
All right, so this is why I say he's green. Instead of saying that's not typical, I would just say no. No, we don't need to do that. Therefore, no. You could just end up. But the fact that the guy's asking for, sorry, the defendant, the respondent, I guess I should say it's civil. He's saying that he needs someone to testify to the fact that the business records are real. Did he use the word real? Come on, man. It's on paper. Just say if the debt's yours or not. If it's not your debt, you go down one line of defense. If it is your debt, then you go into settlement. He's not doing either one, and I'm kind of surprised the judge hasn't flat out asked him that question yet.
question is, I gotta get through is the service. Now, you had mentioned a code and I'm guessing,
Code.
for service,
TRCP, I have all the Texas laws and codes right here to make it simple if you need it. TRCP 106.
okay, and cause I wanna read that real quick and
That's pretty much every case law, that. TRC.
okay, what page am I looking at?
To be honest with you, I can't tell you which page that is. If a personal service fails, the plaintiff must file a motion with the court must.
Okay, I don't see it on 106. I don't know if you wanna point it out to me or not. Do you know what law he's referring to?
I believe he's citing the Texas Rules of Civil Procedure. I'm trying to look up 106 right now.
Cause if I'm not mistaken, I think I know
That's
where he's
fundamental
going.
component of subject matter.
I think he's referring to district, because remember, county and district go by a different set of rules. Texas, the JPs go by another set of rules, and we don't do the 100s. I can tell you that right now. But I don't want to assume, so I'm gonna let y'all go ahead and do that. I can't look it up. I can't make anybody's defense. I'm a neutral party, so I'm just waiting for somebody to give me a rule so I can read it. And while y'all do that, let me get Orlando while you look up that rule.
Yes, Judge, thank you.
All right, Mr. Jones, sorry,
Yes,
give me
ma'am.
a,
So it's actually Texas Rule Civil Procedure 124, no judgment without service. In no case shall judgment be rendered against any defendant unless upon service. or acceptance of waiver of process or upon appearance by the defendant as prescribed by these rules. I didn't accept the waiver of service, and I appeared only to protect myself. So my answer did my service.
Yeah, there's also no judgment against you right now. So that doesn't make sense. You should really understand what you're saying before you say it. Just saying.
The case law that supports it, Wilson versus Dunn, 800 SW second 833 Texas in 1990. A default judgment is void when defendant is not served in strict compliance with the rules, even if they later file documents with the court. And then also Cato
Okay,
Cato
hold
Co
on one
versus
minute.
Castle.
Again, there's no default judgment against them. You're not even to that point yet. You're still in a pretrial before you go to trial. No judgment has been rendered yet. I don't know why he's arguing this.
You had mentioned that you waived service?
No, I did not waive.
Okay, I
service.
thought you said you
No,
had
ma'am,
waived
no, ma'am. I
service.
did not waive service.
Okay, give me 1 minute. Hold on. I'm reading it. I don't need.
I got you.
it. I got it. Right. So, Mr. Brandon, he's quoting, like you mentioned, Texas Rules of Civil Procedure 124. Do you have any response to that? You're on mute, by the way.
Thank you, Your Honor.
Do you have any, whenever you're ready?
Yeah, I'm just skimming it real quick. Your Honor, we're not even at trial yet. We're not seeking a judgment yet. So like I said, we're more than happy to serve him. The whole purpose behind rules such as this is to avoid default judgments without notice of the suit. But it's apparent he has notice. But we're not against serving him if he would like us to. But that, I'm sorry, what was that?
No, even if you serve me, you've already told me that pretty much what you're gonna serve me with is what you already originally filed on the court docket, which still does not give me my prepared requested items that I've asked for and the discovery. And so that's the reason I'm asking for the discovery, because I need to not go into a Hail Mary situation. I need to know what you got. That way I can use justice and, I guess.
All right, so I'm gonna rule on the first motion, the motion to dismiss for lack of service, that's going to be denied. We are not in trial yet, there is no judgment, and just an FYI, Mr. Jones, the JP court follows different rules than the county and district court. We are governed by the rules of 500 on the Texas Rules of Civil Procedure in JP court.
So the rules of 500?
The rules starting at 500.
Okay.
Okay, so 124 does not apply to the JP courts, okay? Because the county and district courts have their own set of rules. And then the JPs have their set of rules, okay? So
Yeah, thank you for telling me that.
you're welcome. All right, so that motion is denied. And so when they want to do the rules of evidence and stuff, that gets a little bit more
Okay, yes, ma'am.
complicated. All right, so Brandon, that motion is denied. So the next motion is discovery.
Yes, ma'am.
All right, let me get you your discovery. So we're gonna have to go into your discovery motion. Cause I want Mr. Brandon to go through the discovery, and I'm gonna go through the most recent discovery, which was on 4/8.
Kind of learned things along the process, so I do apologize.
Okay, so. Let me print this out. Let me make sure I have it. Oh, right here, I do have it.
Do apologize for if I provided too much. I had no idea how to prepare for a case.
No, no,
I'm not
no.
professionally trained or anything,
Do
so
not
I just
ever
wanted-
apologize for coming in over prepared.
Yeah.
All right, so I'm looking at your motion and I just want to make sure that this is it. This is your last one that was filed on April the 8th. And it starts off and then it starts going into production. And then case law. So let me ask you this, Mr. Jones, what you're requesting from them is the original signed credit card agreement or an authenticated digital acceptance of the account terms. Is
Yes,
that?
ma'am. And the main reason is the 23315 Skiller Drive. I'm not familiar with that address whatsoever, and they're saying that's where the account started.
Okay, give me 1 minute. All right, Mr. Brandon, are you objecting to the request for production number 2?
Like, I'm sorry, where are you reading from, Your Honor?
Yeah, okay, so he sent in a motion back in April.
Yes, Your Honor.
Okay, if you go into that, it says number 1, background.
Yes, Your Honor.
Okay, and then if you go down, it says 1, 2, 3, and then right under 3, it's got the request for productions. It's kind of pro se, but you got to read through it. But yes, so that's his first one. Production number 2, original signed credit card agreement or an authenticated digital acceptance of the account terms. Are you in agreement to that, or do I have to make a ruling on that?
In our offering of evidence, there is going to be a card agreement, which we'll file before trial. But the card agreement is typically not a wet signature or a digital signature.
I gave the option, I believe.
So how are you linking this card agreement to Mr. Jones?
Your Honor, this is an account stated claim, and through Texas case law, all we need to provide in our offering of evidence is the business records affidavit and the statements. We include the card agreement to show what their rights under this was, but these are all typically things not included, and so we would object to his motion for discovery.
And I understand they're not typical, but that doesn't mean that they don't come across, okay? So just because it's not typical doesn't mean that it's automatically denied. Okay, he is stating that he's got bank statements from an address that doesn't exist, that he has no idea. So I need some authentication of how you're linking Mr. Jones to this account. So I'm going to go ahead and agree with number 1, maybe not necessarily the original contract, but I need some signature, something linking Mr. Jones to this account. Either, I'm going to leave that up to you on how you're going to link it, but I am going to be inclined to grant number 1. It may not be the originally signed credit card, but I'm going to add some language that as long as it's linking him to this account.
Yes, Your Honor, and we do have an application report that lists identifying information
Okay.
and was provided at the time that this card was applied for.
Okay, so
The only thing
again,
I would say on that, Your Honor, I'm a computer science major in college, and and I understand, I do penetration testing and things like that. So information such as that is very easy accessible. I can do a background check on an individual and get all that information. And that's usually what a lot of phishing scams do, to get information to apply for several credit cards over a period. Also in college as well, they do a lot of phishing and they do a lot of education practices based off of that. So what he's saying technically could, it can be generated.
well, and that's something you can argue in trial.
Oh,
Okay,
definitely. I
because
just
right
wanted-
now it's just a motion, so I'm granting what you're asking for. I don't know what they're giving me yet or what they're gonna give you. And then we will have a hearing on this as well for compliance. Then after that, we're gonna go to trial. So we're gonna baby step this all the way through.
Absolutely, yes, ma'am.
Okay, so your first request is granted. So the originally signed credit card agreement or an authenticated digital acceptance, or I'm going to add anything linking Mr. Jones to this account. However way y'all want to handle that, I'm not gonna make their case for them, okay? I gotta see what they're gonna give me. If I deem that it's fit for us to go to trial on it, then I will. If I find that they're in contempt, that they have not provided that paperwork, then I'll make a ruling at that time.
Yes,
Okay, so your first one is granted with some modification. All right, it's gonna be number 3, interrogatory. It's identification and production of the governing contract and terms for the alleged account. Is that kind of what you were saying, Mr. Brandon, what you were already giving him, the rules and, you know, his rights and stuff like that?
Yes, Your Honor, that I believe that is asking for the card agreement. It's his motion. I'll defer to him on that, but
Okay,
that's my
so-
understanding.
Mr. Jones, is that what you're asking for, the card agreement? On the
I'm asking
interrogatory?
for when the account got initiated, through whoever it got initiated through. I need the initiation agreement, the signature, the things, you know, there has to be something beyond a social and beyond a name that you can do. I don't know if they do any kind of thumbprint verification or,
So
yeah,
this
no,
is just
I
a
don't
regular
know.
credit card.
Yeah, no, but I need something, you know, definitely linking it, you know, to me, especially with the address, not even mine.
Okay, well, that kind of ties into number one. Like I said, that's on them. I already told them that they need to link it somehow. So, Mr. Brandon, we're gonna say that's the card agreement, okay? For that one. Again, I'm not negating number one. They still have to link you to it,
Mhm.
okay? So the next one is going to be the request for number 6,
Yes, Your
and that-
Honor.
the sworn business affidavit, which you have no objection to that. Is that correct?
Yeah, no objection. That'll be included in our offering of evidence before trial.
Oh, excuse me. Okay, so number 6 is granted. Number 7, a full explanation and calculations of the amount claimed as owed. I'm assuming those are gonna be statements.
Yes, Your Honor, we'll be providing statements and that demonstrate where this balance came from.
Okay, so there's no objection to number 7.
I just have issue with the full explanation because under case law, we're not required to provide every statement from the date the account was open. We provide a year of statements that show how the balance gets there. And as long as we could link the account to him, that year of statement should be more than
Okay, well, we'll limit it down to 1 year. That's fine. I don't need 10 years of bank statements printed out. I don't need to kill a forest. All right, and number 4, the documents produced are unauthenticated, lack of supporting affidavit and do not meet the, okay, so number 4 is just a statement, I'm guessing.
Your
Yeah,
Honor, I believe, oh, and he can speak to this as well, but I believe that was a complaint about the debt validation we sent him, but that's not what we didn't file that as evidence. And that's,
Okay, so that's not a discovery, that's just a statement between both parties regarding something that was given to him.
I believe so.
Mr. Jones, is that correct?
That is correct. yeah.
Okay, so the only things that you're requesting are what we've gone over so far.
Yes.
Okay, all right, so we are good on it. He has agreed to almost everything. I just kind of tweaked number 1 a little bit. All right, I'm gonna set this up, council. How long? 30 days to get him all this?
If you could give us 60 days, because like I said, some of this documentation isn't typical. And so give us time to get it from our client.
The only
We
thing I
don't-
do ask, Your Honor, like I said, I am in college. I'm supposed to be doing several trips throughout the summer through my college. Also, I am currently I have custody of my son right now, and I'm currently defending that to make sure.
You're just on a roll, aren't you?
Yes, ma'am. Well, I mean, I've had custody for a few years, but
Okay,
she
okay.
finally got cleaned and came back.
Awesome.
But long story short,
I'm listening to you. I'm looking
I
at my
would
calendar.
prefer to do it a little bit under that 60-day time limit. They've already had 150 days to prepare for this. It doesn't, like an extra 60 days, that puts me at an extremely huge disadvantage.
Okay, so let's split the baby then. We'll do either 30 or 45 days.
I would prefer 30. I mean, I've given them a lot of days already.
Okay, you got to remember that this is only a year old. Okay, so I'm dealing with cases that are 3 or 4 years old.
I
So
got you. I'm not.
No, no,
professionally
I get it,
In this
so-
sector, I just know that I've been very, very active on this case. And
Yes,
I'm not
I have
seeing
seen
the
that.
same amount of activity or near it in my direction.
okay, so what about, are you available on June 12th?
You mind if I?
No, go right ahead. And then you as well, Mr. Brandon, are you available on June 12th?
Yes, Your Honor.
Would you be able to?
As long as it's a Thursday, it's gotta be
Oh,
a
it does,
Thursday.
okay. Then, June 12th it is then.
Are you sure?
Yes, ma'am.
Okay.
I mean, that's enough dates to get everything organized, so.
So I'm gonna reset this.
I was just
know
preferring
it's
a
a
Wednesday.
dismissal document. Okay, and
Is there
remember,
anything
this
for-
is just a discovery hearing, so it should be in and out. Did they comply? Yes, no, and then we will set it for trial,
Is
because
there
we're gonna
anything for
baby
me
step
that I need
this.
to bring to that hearing?
Not at all. It's all on him. He's gotta bring all the
Okay.
paperwork. for- You already requested the discovery. It's his job to provide it now. And that's why I went through it each one by one, so he's aware of what needs to be provided.
Yes, ma'am.
Okay, so he's gonna send it to you. Take this folder, bring it back to me during trial. I don't want to be responsible for that. And I want to keep that and make sure that I have that for trial, okay? All right.
So you said he's sending it to me, like it's gonna come in my mail or?
Yes, so do you want him to, do you want to provide an email maybe?
Oh, absolutely. I
Okay.
can provide an email.
Swing around here to the right. I
Okay.
don't mention it out loud because everybody on YouTube's gonna know it. All right, Mr. Brandon,
All right, that is about it. There's still about 10 seconds left, but they're finished. I don't know when I cut it out. But closing statements. I do think this guy is leaning soft-cit. I really do, which is why I put soft-cit adjacent in. Some of his arguments just they don't work. But he's doing a lot of research. He fought a lot of motions. As far as pro se goes, he didn't do a bad job. A lot of his arguments did have merit. Some of them didn't. But the attorney on the other side, you can tell he's green. I'm not going to say he doesn't know what he's doing. He's just not very fast. He's not very fast to respond. He also seems to not be very affirmative. You know, the one example I had is he didn't say, no, we're not going to do that. We don't have to. Instead, he, kind of beat around the bush and said that's not normal. And that he said that a couple times, and the judge actually started saying it because he said it so many times. All right. Yeah, that's about it. So please hit the like button if you enjoyed it. I would appreciate it. And June, what did they say? June 12th, I think. I don't remember. June 6th, maybe. I wrote it down. I don't remember what they said. But I will watch that hearing, and then we'll absolutely watch the trial. Hopefully I'm right, and this guy does start going soft-cit. But maybe he's just a try-hard pro se. And there's nothing wrong with that. Anyways, that's it. Have a great day. Until next time. Bye.
before you get out, we're gonna give you, Mr. Jones's email, so that way y'all can provide better communication a lot faster.
Okay, and then, Your Honor, are you gonna be signing an order granting discovery?
Yes, my clerk is
Okay.
gonna go ahead and make that order right now.
Okay, perfect.
Okay, and we'll review it as well. What do you need from this?